Hello, welcome to my channel. My name is Katie and this is where we discuss true crime, current affairs and politics. If that sounds like something you're interested in, please subscribe to the channel. And if you are a returning viewer, thank you. Hello, welcome back. Today we're going to continue in our coverage of the Kouri Richins case. If you haven't been following this case, oh my days, it's messy. And I have recently found a lot more documents for this case, so I'm going through them. Slowly but surely, I'm going through them. I have a whole playlist. I'm working on a timeline video, so what has happened up until now in the case. When that will be ready, I don't know, because something happens every day in this case. But a few videos ago, we covered, what was it? The prosecution accusing the state of breaking their own gag order. I found the response from the state, and I've just read through it. It is so funny. It shouldn't be, but it is. It sounds like Mean Girls between these two groups of lawyers. It's silly. But if you don't know the case, Kouri Richins was arrested in May this year on the allegation of murdering her husband, Eric. She is currently in jail, awaiting trial. She was denied bail. She is currently presumed innocent. And please keep that in mind, and also please keep in mind that our children involved in this case. As much as we have a bit of a giggle and we poke fun, please keep that in mind. And this case is just taking up everything on this channel. Everything else I was covering has just gone to the side now. So I hope you're here for it. I hope you want to go down the rabbit hole with me, because that's where we're going. So let me get the document up. There we go. And we are going to have some fun. So, that one. Here we are. So, this is in opposition to the motion to enforce order and for contempt sanctions. Now, they don't date their documents, and it's really irritating. If you know where they date their documents, can you tell me so I can find it, please? Thank you. So, State of Utah versus Kouri Richins, and the case is being seen by Judge Richard Razik. I hope I've been saying that right. But here we go. Statement for relief sought. The court, now remember, this is the prosecution team. Okay, this is what the prosecution are saying about what the defence said about them breaking their own gag order. The court should deny Kouri's motion. When I say Kouri, I mean the whole team, the whole defence team. Kouri's motion to enforce order and for contempt sanctions. The motion is a fire, aim, ready reaction to Kouri's misconduct in the jail. What? Is that one sentence in and it's already getting catty, in my opinion? The motion contains factual errors and legal misunderstandings, rendering it unpersuasive at best. The state has an obligation to protect this proceeding from witness tampering. Consistent with that obligation, and as a matter of necessity, the state filed a motion for no contact order. That motion was based on the defendant's witness tampering and breach of jail security procedures. The walk the dog letter is an exhibit to the state's motion. If you don't know what the walk the dog letter is, I have done a video on it. It's something. You don't need to know the content of that letter to continue reading this with me, but it might be worth a watch after this. Okay, so statement of facts. On September the 13th, Kouri had a telephone call with her mother Lisa. Kouri read aloud a portion of a letter written to Kouri by another inmate. Inmate to inmate correspondence is prohibited by jail rules. On September the 14th, the defendant had a video call with her mother. Kouri held up the multi-page letter over the video so her mother could read or photograph it. The defendant did not read the letter aloud. So that's letter number 2. I don't know if I have those. I will let you know. Later that day, which was on the 14th, the Summit County Sheriff's Office searched the defendant's cell. Neither letter number 1 or letter number 2 were found. However, the Walk the Dog letter was discovered, hidden in an LSAT prep book located in Kouri's cell. Bit of background, Kouri is studying for her LSATs so that if she gets out, she wants to help people who are wrongly accused. The state's motion for no contact order was filed the following day on September the 15th, based upon the witness tampering described in the Walk the Dog letter. There's a link in the description to the Walk the Dog letter. You should read it. It's just, you just want to take the pens off her. Girl, just like sit on your hands and keep your mouth shut. Please, it'll make my life easier as well. I've already got enough documents. Anywho, we'll go back to this one. On September the 16th, which is the day after the state filed a no contact order, the defendant had a telephone call with her mother. The defendant described the Walk the Dog letter as an excerpt from a fictional book that the defendant is writing about her stay in a Mexican prison. Okay, sure, yes, of course you are. The defendant explains, when I first got in here, so this is her talking to her mom, I believe. When I first got in here, I was telling you how I was writing a book. Those papers were not a letter to you guys. They were part of my freaking book. I was writing this fictional mystery book. I go to Mexico and I'm like trying to find these medicines. If I highlight that word, I can't. Anywho, illegal medicines. I'm writing about Dad. Like, me and Dad went to Mexico to find these illegal medicines. You can very much tell that the whole thing is very much a story. Then I get in the Mexican prison. I said have Sky sneak me in some white strips because my teeth are getting yellow because all we do is drink coffee in the Mexican prison. And there's a footnote here. Since the beginning of this matter, the state has filed its exhibits as freestanding docket entries and referenced these docket entries by number. This makes a clean record, eliminates duplicates, and is consistent with best practice in complex litigation. Just a side note that little bit. So the next part, legal authority and argument. The state did not violate the court's gag order. The court's narrowly tailored gag order applies to extrajudicial statements. The state has not made any extrajudicial statements. The Walk the Dog letter is an exhibit to the state's motion for no contact order. This is the very definition of a judicial statement. And then they actually give a definition. And they define extrajudicial as outside court, outside the function of the court system. This court has been very clear that all issues in this proceeding will and shall be conducted transparently and with an associated public record. The Walk the Dog letter is an exhibit and a material one, which provides critical justification for the state's request for relief. As a footnote, the motion filed by the defence also suggests that the state violated the court's gag order because filing the walk the dog letter disregarded the parties' stipulation to produce documents in a specific, orderly and formal manner. It is difficult to imagine a production that is more specific, orderly and formal than a judicial filing. Like, I need a cup of tea here because, ooh, catty. It is also difficult to reconcile the motion's argument that the state produced the letter extrajudicially with its argument that the state produced the letter in a judicial filing instead of pursuant to the discovery stipulation. So the state are saying that the defence have accused them of doing something that's extrajudicial, but have then said that it is judicial, from what I believe, from what I understand. The disclaimer, I am not a lawyer. Okay, this is just what I am understanding from the document. If I am misunderstanding, please let me know in the comments. And while I'm here, don't forget to like the video. Notwithstanding these contradictions, the state produced the walk the dog letter pursuant to the delivery stipulation contemporaneous to filing its motion for no contact. It is bait stamped pursuant to the established document control measures in this case. And whether the state produced the letter in a manner technically inconsistent with the discovery stipulation is completely irrelevant to whether the state violated the court's gag order. No comment on that bit, I don't get it. In another footnote, the motion vaguely raises a threshold matter of whether the walk the dog letter is a privileged attorney-client communication. The motion does not indicate how this matter is threshold to determining whether the state violated the court's gag order. Regardless, the state will address this issue. So I didn't really quite understand what one of that was, but they're saying the previous thing that I said is there's neither here nor there, but we'll address it anyway. That's what I took. The defendant asserts that the walk the dog letter is a privileged attorney-client communication because, upon information and belief, a sheriff's deputy recovered it from an envelope that was labelled Sky Lazaro, attorney privileged. A sheriff's deputy in fact recovered the letter from the defendant's LSAT prep book. Since the motion to enforce order and for contempt was filed, the defendant has characterised the walk the dog letter as a work of her own fiction writing, not a letter to her lawyer. So they're saying in one breath that the walk the dog letter is privileged attorney-client communication, and then in another breath saying that it's a work of fiction. Regardless, hiding a non-privileged communication in an envelope labelled privileged does not magically transform it into a privileged communication. Ooh. If it did, such envelopes would quickly be converted to devices for circumventing jail safety rules. Moreover, as the motion recognises, sheriff's deputies are allowed to inspect the defendant's legal envelope to determine whether she is using it to hide contraband. The walk the dog letter is evidence of a crime, which is classic contraband. And there's footnote. The motion's use of upon information and belief here is extraordinarily curious because it highlights the defendant's use of the same phrase in her walk the dog letter. To any objective reader of the letter, the defendant views upon information and belief, followed by LOL, as providing carte blanche to fabricate a narrative. The walk the dog letter is not a privileged attorney-client communication because it speaks directly to defendant's mother and includes passages about the defendant's attorney not to the defendant's attorney. Its audience, content and purpose are readily apparent. The defendant, Kouri, is asking her mother to facilitate witness tampering involving her brother, seeking to have her brother support a false factual narrative. Even if the court credits the defendant's far-fetched explanation that the letter is somehow a note regarding a fictional Mexican prison, the letter would still not constitute a privileged attorney-client communication because it was not addressed to the defendant's counsel for the purpose of securing legal advice. The addressee is clear from the content of the letter. The state did not violate Rule 11. The motion seeks sanctions generally under Rule 11b, which governs 4 specific representations of veracity that a party presents to the court in a pleading, written motion or other paper. The defence did not identify or argue a specific subsection of Rule 11b because none of them apply. Nor did the defence follow the procedure set forth in Rule 11. Instead, the defence simply complains that the state disclosed the defendant's confidential information. Such a complaint does not implicate any of the state's representations to the court. Accordingly, the defence's quest for sanctions under Rule 11 is misplaced. Regardless, the state has acted in good faith with its handling of the defendant's confidential information. The state has filed several hundred pages of documents in support of its prosecution of Kouri for the aggravated murder of her husband. The state has redacted confidential information contained in scores of these documents. On a few occasions, the state inadvertently failed to redact confidential information. In each instance, the state acted quickly to seal the document as soon as the state learned that confidential information was public. And there's a footnote. In haste, the motion inaccurately asserts that the state has disclosed confidential information on countless occasions. This type of hyperbole is unproductive. Is it hyperbole, 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 hyperbole? What do you think? Let me know. In the first instance, as the motion notes, the state took the extraordinary measure of contacting the court on a Sunday to seal the document. In the first 2 instances, the defence immediately notified the state that certain confidential information was public. In the third instance, on September the 15th, the defence did not immediately notify the state that certain confidential information was public. Instead, the defence appears to have withheld this news so that it could argue for sanctions. The motion drew unnecessary attention to their client's confidential information before the state had an opportunity to seal the inadvertently disclosed information. The defence seems more concerned with sanctioning the state than protecting its client's confidential information. In conclusion, the state respectfully requests that the court deny the defendant's motion to enforce order and for contempt of sanctions, 19th of September. So that's those 6 pages. Is it just me, or are these lawyers getting nasty? Like, they're just scoring points against each other at this point, like popping their heads over the parapet, and like it seems silly. But they have some good points. But then again, the defence will also have some good points. You know, they've already set out why they think they broke the gag order. So it doesn't look great when the lawyers are arguing between themselves, in my opinion. So what do you think about this one? This motion to basically say, oh, we didn't break the gag order, actually, is pretty much what they're saying. Have I misunderstood? I don't think so. I hope not. Maybe I have. If you're as obsessed with this case as I am, I've been following it since Kouri was arrested back in May. So if you are just as obsessed as me, make sure to subscribe to my channel because I will be covering it a lot more. Kouri is next due in court on the 3rd of November, and we hope that they will set a date for trial at that hearing. Whether they will or not is another matter. Something else could happen in the meantime. This case just keeps on giving. If you want to catch up, there's a whole playlist, and in the description there is a link to a Google Drive file where I have saved all of the documents that I have found. And I have found a lot more. Last night I was going through them all, trying to figure out if I had duplicated. I don't think I have. If you see any files that are duplicated, can you let me know on here or on my socials? And I have a lot more to go through to add to that file. So that's what. So yeah, help us out to those documents. I believe if they are publicly available, why shouldn't I share them? I got them from someone sharing them, from someone sharing them, from someone sharing them, because they are publicly available. There was something else I wanted to say. If you're here from the Reddit community, thank you. I appreciate your time. You all know how important it is to me. Thank you. And if you've come over here from the Facebook group that I have recently found, hi, welcome. This is my face, and this is where we cover the case. My channel will probably just be Kouri Richins for quite a while. I apologise if you're not into that, but there is just so much. In regards to the politics and current affairs, I will probably be uploading to TikTok. It's a lot easier, a lot quicker, because there's no documents in that. It is just pointing out how idiotic the Tory government is. So that's the end of my rambling. What did you think of this document? Is it as entertaining to you guys as it is to me? Are you obsessed with this case? What got you into this case? Personally, for me, it was the headline, author poisons husband, allegedly. That was the headline that I saw in May when Kouri was arrested, and that was it. I have been hooked ever since. And as I said, I am working on a timeline video. It's just taking me a while. But I will continue covering the documents. They are out of order. They are old. I'm not going to lie to you. But I can't. It's just me doing this. So bear with me. But thank you for your time. I appreciate it. Come follow me on all of the socials. Give me a like and a comment. Let me know where you've come from, how you found the video, and don't forget to subscribe so you never miss an episode. And I will see you in the next one. Thank you very much. Bye.